The Trump administration has never been shy about proclaiming itself the ultimate defender of free speech. From campaign rallies to press briefings, the message has been loud and clear. No one champions the First Amendment quite like Donald Trump. Yet when immigration judges, actual officers of the law, attempt to speak publicly, even in their personal capacity, about the system they work in every day, suddenly free speech becomes a problem that needs judicial containment. That contradiction was on full display when the Supreme Court declined the Trump administration's request to intervene in a dispute over a policy restricting immigration judges' speaking engagements. In a brief unsigned order, the justices refused to block a lower court decision allowing further fact-finding on whether the administrative system governing federal employee claims remains independent from presidential control. The court did not deliver a dramatic rebuke. It did something far worse for the administration. It calmly said no. Legal scholar Stephen Vladek described the decision as the Trump administration's first real loss at the Supreme Court since April. And while the ruling was procedurally modest, its symbolism was not. For a White House obsessed with projecting dominance over the judiciary, even a temporary refusal to bend the law to executive convenience is an unwelcome reminder that constitutional limits still exist, at least on paper. At the heart of the case is a policy that the National Association of Immigration Judges says bars its members from speaking publicly, even as private citizens, about immigration policy and the agency that employs them. In other words, the people tasked with interpreting and enforcing immigration law are expected to remain silent about how that law actually works in practice. Expertise, apparently, is acceptable only when it agrees with political messaging. The NAIJ challenged the policy on First Amendment grounds, arguing that it violates basic principles of free expression. The case was initially dismissed by a federal district judge who ruled that under the Civil Service Reform Act, the judges were required to pursue their claims through an administrative review process rather than in federal court. But the U.S. Court of Appeals for the Fourth Circuit was less convinced that this administrative pathway still functions as Congress intended. The court pointed to recent actions by President Trump, specifically his firing of both the special counsel and the chair of the Merit Systems Protection Board, as raising serious questions about whether the system remains independent from presidential influence. If the referee works for one of the teams, the game stops being fair. This was not an abstract concern. The special counsel is the first stop for federal employees seeking redress, and the Merit Systems Protection Board serves as a crucial backstop. By removing both figures, the administration effectively hollowed out the very independence that justifies forcing employees to use the administrative process in the first place. The Fourth Circuit therefore sent the case back for additional fact-finding on whether the adjudicatory scheme still has any continued vitality. That prospect sent the Trump administration into emergency mode. Solicitor General D. John Sauer rushed to the Supreme Court, warning darkly that unelected judges were improperly updating statutes based on political developments. The argument was rich with irony. An administration that routinely stretched executive power to its limits was suddenly alarmed by judges asking whether the law still functions as written. Sauer also claimed the ruling would create destabilizing uncertainty across the federal government, potentially threatening other administrative review schemes like the Federal Trade Commission. Translation: if courts start asking whether agencies are truly independent, a lot of executive power grabs might start looking constitutionally inconvenient. Chief Justice John Roberts granted a temporary administrative stay, buying the court time to consider the government's request. But when the justices finally weighed in, they declined to intervene. The government, they ruled, had failed to demonstrate irreparable harm. Fact-finding, it turns out, is not a constitutional crisis. The court did leave the door open for the administration to return if discovery proceeds too quickly. Even so, the message was unmistakable. The judiciary is not obligated to freeze reality simply because the executive branch finds scrutiny uncomfortable. For a president who regularly derides judges, agencies, and career civil servants as obstacles to his will, the decision is a reminder of an inconvenient truth. The Constitution does not grant the White House veto power over facts. And free speech, despite the administration's rhetoric, does not come with a loyalty oath. In Trump's America, speech is celebrated when it flatters power and restricted when it challenges it. The Supreme Court's refusal to play along, at least this time, suggests that the First Amendment may still have a few defenders left.